Today I wish to articulate and advance a very important aspect of a criminal proceedings. And I wish to talk to you about taking a plea. Now, a plea can be taken at the magistrate's court or at the high court. Whenever you hear that someone has taken a plea or has to take a plea, it would mean that that person is involved in a criminal proceedings. So we can conclude safely that a person can only take a plea in criminal proceedings. Now, a plea is what a person who is charged must take before a trial can legitimately begin. Now, of course, you would understand that a plea is only taken with the permission of a magistrate, or in the case of a high court, it is only taken with the permission of the judge. Now, in more than one occasions, there must be an offense in which the person has been charged with, and that the person must be fit to take the plea. Now, what do we mean when we say that the person must be fit to take a plea? It means that the person must have the mental capacity to understand the nature of the proceedings, or to understand that they have been charged, and they must understand what is being read to them in a court of law. So when we talk about a person must be fit to take a plea, we are talking that the person must have the mental capacity to take a plea. Now, it is important because it is an important facet, as I would describe it, of the criminal proceedings, that the person who is charged must know what the entire matter or what is transpiring in the court, because it is a fundamental, and we must understand that many of the rules, whether these rules come from common law or whether they come from a law made by statute, the premise on which these laws have been formulated is from a constitutional basis, in that one has a constitutional right to know what they have been charged with. They must understand what the charge is. It will mean that if a person who is not native English, and the person does not speak English language, and the charge is being read in English language, then the law provides that the person who is adjudicating over that court must allow that person to have an interpreter, so that someone can repeat what was said in English in that language that the person will understand. So this is how important it is to ensure that the person understands what is transpiring in the court. Now, when we talk about a person taking a plea, there are three main pleas that we can talk about. The person, it can either say, I am guilty, and I will explain that in more detail shortly, or the person can say, I am not guilty, and I will explain that further. Or the person can, of course, be prevented from taking a plea because there is a plea in bar. Now, I will attempt to explain the two most important pleas that a person will take in a court. Now, we must understand, before we go to a guilty plea, we must understand that a plea must be taken personally. What does that mean? It means that you cannot stay from somewhere, or what we say, you are appearing in absentia, meaning that you're not appearing in person, and that you have someone come to the court and say, my father or my mother, or say that they are guilty. The law doesn't permit that. The law will say clearly, or has said clearly, that the person must take the plea personally, meaning that if you are charged, you must appear before the court and you must answer the charge when the given opportunity comes. Now, there are two areas or types of offenses in which I will take just a brief minute to explain to you. There is what is called summary offenses, in which the charge is read to you, and of course those summary offenses are those less serious offenses that the criminal law describe, meaning that the penalty for such offense will of course be less than 2 years. Now, of course, there is what is called indictable offenses. And of course, indictable offenses are offenses which are serious, which means that the penalty will be over the 2 years if one is found guilty. Now, there is a reason why I have mentioned that to you. Because if you are charged with a summary offense, it will mean that the charge will be read to you, and immediately, once you understand what has been read to you, the magistrate will invite you to enter a plea. What is that? To allow you to say whether you are guilty or not guilty. Now, if you are charged with a serious offense, and that is called an indictable offense, it will mean that the magistrate must allow an application to be made for the matter to be heard in the magistrate's court and determined in the magistrate's court before the magistrate can invoke that power to invite you to enter a plea. Usually that is an application made under the Administration of Justice Act, or what they come short in common we would say the AJ, as to whether the AJA has been applied. Once that has been applied for a serious offense, the magistrate will then read the charge back to you and will then invite you to enter a plea. Now, a plea must be unambiguous. What does that mean? It means that there must be absolute certainty in relation to what the person has said. So if the person has answered and the court is not sure what the person has said, of course, the court cannot go further to record on the case jacket that the person has entered a plea. So it must be clear. All right? There must be absolutely no ambiguity with what the person is pleading. Of course, before one takes a plea, the charge must be, of course, explained. So in this explanation, the court, before inviting a person charged to take a plea, may very well ask the prosecutor to read your facts. What are the facts? Exactly what the police have alleged that you have done is what must be read out to the court. Then the court, before that court, the court accepts your plea, the court must ask you whether the facts that was read by the prosecutor, whether that fact is true or not. Now, if you believe that the facts which were stated by a prosecutor is not the truth of the matter, ultimately you are not accepting that what the prosecution is alleging that you did is what you did. Therefore, your plea is going to be not guilty. Now, if you haven't listened to the facts, you give an explanation as to what happened on the material date. If that explanation differs from what the prosecutor had said, it is clear that the magistrate must accept that you have not accepted the facts as read by the prosecutor. Therefore, the magistrate will most likely record a not guilty plea. Now, it is important for us to understand that where there are, of course, a plea which is unequivocal, meaning that it is clear, you must not be accepting different facts. It must be what you believe is what happened. Now, of course, the law allows you to make sure that your plea is a voluntary plea. What does that mean? It means that you must not be prompted to enter a plea. You must not be forced to enter a plea. You must not be threatened to enter a plea. And of course, there must be no undue pressure for you to enter a plea. The plea, when you take a plea, the plea must be a voluntary one. Now, let us go to what is a guilty plea. A guilty plea will be that you accept the facts as read by the prosecutor, that all that they have alleged that you did and what you did breeds or formulates what the criminal liability will say is an offense. If you accept that, of course, your plea is guilty. If you do not accept what the prosecutor said that you did, then that is a not guilty plea. Now, what if the person remains silent? The court invites you to enter a plea, but you do not answer. Now, in law, we will say that the person is muted. Now, if that is the situation, the magistrate cannot assume that the person, by their mere silence, has accepted that they did a particular act, or that they do not accept that they did a particular act. So that the common law, has only made one solution where a person doesn't answer when the charge is read. The trial must proceed, and the magistrate must not enter a plea that was not stated. Now, if the person, let's say, the person received an advice from some family member or from some person who may not have been au fait with certain legal principles and law, and the person decides, listen, I don't really like the court, and I don't really want to be a part of the court proceedings, so that it's just a fine or time, I'm going to just plead guilty and bring an end to the matter. But let's say you decide after that what you did was not the correct decision. You had not made the correct decision. Then can you change your plea? Can you change your guilty plea and enter a not guilty plea before sentence is passed? The answer is yes. You can change your plea up to the time in which sentence is passed. So that if the magistrate has passed sentence, whether the person is to be imprisoned or the person is to pay a fine, then that is the end of the matter. In law, we will say that the magistrate has become functus, meaning that the magistrate no longer has power to preside over that matter when sentence has passed. Of course, if sentence has not yet passed, of course, you can change your plea. Now, what about where you enter a guilty plea, but the magistrate asked you to explain what happened? And in your explanation, there exists a defense in law to what had happened. Then the magistrate is obligated by law to enter a not guilty plea. So that, let's go that again. If you said, I am guilty, and this is a situation in which someone attacked you first, and then you defended yourself. But in defending yourself, you caused injury to the person, and you were charged. But the facts which is read at the court now will say that on a particular date, you armed yourself with an instrument, with an object, and you caused injury to Y. You would say, well, that is the truth. I caused injuries to Y. And you say, okay, I'm guilty. The magistrate now invites you to explain the circumstances which cause you to cause injury to the other person. And in your explanation, there is the defense of self-defense, in which you were attacked and you were protecting yourself. And you were protecting yourself from the person, from Y, for the injuring you. Then the magistrate must not accept your guilty plea. The magistrate must now enter a plea of not guilty. So in a nutshell, there are certain important things that you must know when you have been charged, or if you're ever charged, or anyone is ever charged for you, and you go before the courts. There are some vital things that you must know. One, the facts of the prosecution's case must be clear. It's important that those facts are clear. So when the charge is read to you and the prosecution is given an opportunity to state their facts, you must understand what the prosecutor is saying. You must accept that facts only if you believe that is what happened. If you believe that is not what happened, then you must not accept that facts. You must reject the facts. It will mean that you must enter a not guilty plea. Secondly, you must not be pressured to enter a plea. You must do that of your own free will. There must be absolutely no undue pressure for you to enter a plea. Entering a plea is important only because it allows the trial, or it allows the criminal process to legitimately begin. So that if we do not get to the stage of plea, then the magistrate cannot proceed with the matter. That element of the process must be completed. And thirdly, when giving a plea, you must be clear. It must be unambiguous, and it must be very much clear as to what you are pleading to and what your plea is. Fourthly, if you decide before sentence is passed that what you did was a mistake and you wish to correct your plea, then you can ask the magistrate to change your plea. Now, you can change your plea before sentence is passed. If sentence is passed, then the magistrate has no power to entertain your application to change the plea. It will mean that from that court, the only court that you can go to is a higher court. And we will talk about your right to appeal, where you find that these elements or mistakes were made, your right to appeal in a subsequent discussion.